On the case of Berkeley versus O'Reilly Automotive Stores, our case number 40703. As I understand it, petitioner has 25 minutes for opening and 5 minutes for rebuttal.
That's correct, John.
And the respondent has full 30 minutes. Okay, you may proceed. Please enter your appearance and you may proceed.
Good afternoon, Your Honors. Tim Adler and Raul Cedillo on behalf of petitioner O'Reilly Automotive Stores. Your Honors, I want to just say from the outset, we've got a stomach flu going around my house. And so I think you're all inside the slack zone, but I just wanted to give fair warning about that. We greatly appreciate the opportunity to be here before the court today. This is a case on interlocutory appeal that almost went under the radar. It is an appeal about protecting the integrity of the judicial process. Plaintiff's counsel used the Wrongful Death Act appointment proceeding to secretly compel sworn testimony outside the rules of civil procedure, issuing subpoenas without a pending action, without notice to my client O'Reilly, and without the safeguards that the rules require. I'll make 2 points today. First, that a concluded appointment proceeding is not a pending action that permits compelled pre-suit discovery. And second, that the remedy for this unauthorized use of court process must be dismissal or, at a minimum, suppression of the improperly obtained information. So turning to the first point, Your Honors, a concluded appointment proceeding is not a pending action that enables ex parte pre-suit discovery. And the rules of civil procedure make clear that there can be no discovery without a pending action. Rule 26B authorizes discovery only in a pending action. And Rule 45, the subpoena rule, also refers to a pending action.
Mr. Adler, what causes something to no longer be a pending action?
Well, what a pending action means, Your Honor, is that something remains to be decided. And in this case, the appointment proceeding was completed the moment the district court in that proceeding entered the order granting the appointment. That happened 1 day after the petition for appointment. Then there were 19 months that followed that, over the course of which 3 examinations under oath were taken under the captain of that proceeding.
So, in a PR petition under the Wrongful Death Act, if somebody, say, Justice Vigil is appointed as the PR under case number 1, and then he determines that he can't do the task. So now there's going to be a request to appoint Judge Chavez as a PR. Could that be done under the same case number, or would it have to be done under a separate case number, a new filing?
I think it could be done under the same case number, Your Honor, but the important point about your question is that the scope of the work the district court is called upon to do there is to appoint a PR.
But I asked the question because I think it sheds some light on the definition of pending. Because if you can continue to do something within in a case, it might suggest that it's still pending.
I think in the strictest sense, Your Honor, that may be true. And again, I think O'Reilly would concede that PR appointment proceeding is a civil action subject to the rules of civil procedure. But once the relief is awarded and the petitioner and the PR is named, the purpose of the statute is fulfilled. And I think it's important to...
So it's a better analogy rather than focusing on the word pending? Is it a better use of terminology to say that it's a final order? The appointment of the PR is a final order. And so the judge at that point could, dismiss the action. They could close it for lack of prosecution, a variety of things. But is it more important to focus on this as a final order than the term pending? And is there a difference?
I don't know that there's a great difference. I don't think they're in conflict. I think the point is that we have to ask ourselves, what is the Wrongful Death Act asking us to do?
What's it for?
Yeah, what's the reason underlying it? And the case law says that the purpose of the appointment proceeding is to name someone to stand in the shoes of the subject, so that the action won't fail for the lack of a nominal party. And so that purpose is vindicated and completed at the time when the appointment court goes ahead and appoints the PR. And there may be situations where it's not clear who should be the PR. Maybe there needs to be some discovery about that before the appointment order is issued. And then maybe, as Your Honor suggests, maybe someday someone wants to come back and reopen that proceeding and argue that there was a problem with it.
Mr. Adler, can I ask a question on that? So I think that hypothetical, under the Wrongful Death Act, you seek a personal representative to be appointed. And, 9 times out of 10 or even more, the judge enters that final order within a day or two. But let's imagine they didn't enter the final order. So you're waiting for that assignment to the personal representative. What would you see would be permissible discovery under 26B in that action? There's not a final order, but what would be relevant under 26B?
I think discovery under Rule 26 is always, the scope of it is always set out by the terms of the operative pleadings. So the petition for appointment, I think, would set the scope of that. I think if someone's opposing it or responding to it, then that's part of the scope. But the wrongful death claim itself, having not been filed, cannot be a part of discovery. And the Act and Rule 17 allows those to be brought together. I think in this case, if they had been brought together, the discovery rules would have applied and notice requirements would have been at least imposed. But that's not what happened in this case. The appointment proceeding can be brought, as it was here, as a standalone proceeding, and it was completed at the time the appointment was made.
Let's look at the order that was entered. The order said it's Murphy is appointed PR for the purpose of investigating and pursuing a wrongful death action. So can't that order be construed to allow discovery for the purpose of investigating and pursuing the wrongful death case? And wasn't the discovery that was actually pursuing this case conducted to that end?
Absolutely not, Your Honor. It can't be construed that way. So there's a
Well, that's what it says.
it says investigation, and O'Reilly has no quarrel with that language. But investigation and discovery, as the Wisconsin, or I apologize, the Wyoming Supreme Court in the case we cited, are plainly different things. Any plaintiff has to conduct a pre-suit investigation under Rule 11 to make sure they have good grounds to file suit. That doesn't authorize.
Discover, I don't buy your distinction between discovery and investigation. All discovery is a form of investigation. Is it not?
That is true, Your Honor, but there is a difference. It's important, and I'd like the chance to address it. So in any case, like I mentioned, a plaintiff has to satisfy Rule 11, or counsel does, that there's a good ground to bring a case. And we're a notice pleading state, the bar is not that high. But once the case is initiated, then the rules of civil procedure kick in, and notice has to be given to opposing parties, to targets of discovery, and all the protections that come with the rules apply. It is not the case, Your Honor, that in an ordinary pre-suit investigation, an attorney can use the compulsory process of the court to compel mandatory attendance and testimony and production of documents in this case. Using those rules, you have to commence an action, and that's actually what this court held in the In re Chavez case. The court said unequivocally it is unlawful for a court or an officer of the court to issue any subpoena in the absence of a pending judicial action. So that means that even if someone wants to conduct, and they should conduct, pre-suit investigation, that does not mean that they can issue subpoenas. Pre-suit investigation can include interviews, can include consulting public information, in this case, probably a police crash report. It can include consulting an expert and gathering the information needed to be able to satisfy Rule 11. But then when you shift into actual discovery under the compulsion of court process, that is an entirely different thing. And that's what this case is all about, Your Honor.
So I'm curious, just to switch gears, about your request for a remedy here. So the twofold inquiry, versus the standard of review, which is abuse of discretion. Pretty hard standard for the appellant to overcome here. But also, if there is, even if we agree with you about the scope of discovery and what the appointment proceeding is for and not for, why is this the nuclear option? And first, I want you also to address dismissal of the case. that suggests that there has been gross misconduct. The second is suppression. And it kind of, granted, I fully recognize this is a civil case, but I'm really curious about it's kind of like a concept of inevitable discovery. Sure, had the interviews subject to subpoena happened with O'Reilly in the room, you would have interposed object to form, and then did out in court over what's admissible and what's not admissible in fair game. And that can happen anyway here. So I'm not sure, so I need to understand what you have to support the idea that this is somehow gross misconduct, or that suppression is the right answer through the lens of abuse of discretion.
Absolutely, Your Honor. So we'll start with the standard of review, and it is abuse of discretion. It is a high bar generally. It's not an impossible bar.
It's not impossible. I agree.
And in this case, the district court awarded no remedy. And so to award no remedy in the face of a clear rule violation is itself, by definition, an abuse.
You say it's a clear rule violation. I'm not sure this court's going to agree with you that it's a clear rule violation.
We want the court to agree with us.
I know you do. But that's why I'm trying to explore this, because I'm not convinced this is a clear rule violation. I think, we've got 120 pages of briefing that suggests that it may not be so clear. And so then what's the judge supposed to do with that? And then what are we supposed to do with that on review?
We think the court made it clear in Ray Chavez that, and for multiple good reasons, why you need a pending action before you can issue compulsory process.
That assumes the action ends when the order is entered.
Excuse me, Your Honor?
That assumes the action ends when the order is entered, appointing the PR.
It does, and we think that we think that is consistent with the statute and with our analysis. Otherwise, what we're risking here, Your Honor, is sort of twilight zone between the appointment and the actual filing of the wrongful death that creates a loophole that plaintiff's counsel tried to exploit here.
Mr. Adler, so if anybody's aware of Ray Chavez, it's me. And as to that, so we'll get that out of the room. As far as it goes, let's imagine we're not talking about this, but again, I'll do that hypothetical. They get discovery that they weren't supposed to get. They came into the offices, however they got it. What would you do? You'd bring it to a district judge or the trial judge. You'd ask for sanctions. The judge would determine, this impermissibly obtained discovery or whatever the violation is, and they would determine the appropriate sanctions. And that would be generally the course of the case. I want to turn to real quick is when we're even talking about the sanctions, Judge Matthew only certified the narrow issue of whether it was a complete action. And so can you tell us why it's properly before us? Even if we agree that it's the case is over once there's an appointment or the discovery is outside of Rule 26, it would be up to Judge Matthew to say, okay, we're excluding all this evidence. Or how was it prejudicial if we had a deposition and you got to object? And, what did they get that they shouldn't have got, and how did it prejudice your client?
So, Your Honor, first, to address the question, why is it properly before you? Judge Matthew did certify the the question about the pending action, but he also said that the resolution, because plaintiff's claims were based completely on this improperly obtained information, that the resolution of the question could materially advance the ultimate termination of the case.
But then doesn't that beg for remand rather than us weighing in on the remedy?
It possibly could, and I'm prepared to talk about that a little. But I do want to answer both Your Honor's questions about the remedy, because it's very easy, and I think the district court struggled with this a little bit. It's very easy to look at a deposition and say, well, you know, if counsel is present, maybe they object a little bit here or there. I think the problem with looking at it that way is it overlooks what we expect in every single case, which is if you're given proper notice of a deposition coming up, the client is entitled to counsel. That means not just showing up and objecting, but actually talking about the evidence, preparing, being there to protect privileges if they come up, having an idea of the entire case and the defense. That was all done. None of this O'Reilly was even aware of for years until the wrongful death suit was actually filed. That is not something the court should allow. We think it is extremely troubling and serious when a party goes out of their way to exploit a purported loophole to get this kind of advanced knowledge outside of the rules of civil procedure.
So I'm going to go back to my, maybe an inartfully asked, but my original question here. If the court determines that this was a reasonably fair question, but we resolve it in your favor, what's the remedy? Because if we think it's, you know, it was a fair, it was debatable, and we're going to call the ball. The two proposed remedies you've given us would be far too big for the conduct.
If the court thinks it's debatable, that may be so. However,
I mean, it would be so, because let's say it's debatable.
I understand, but then we have to ask ourselves, what's the alternative, right? Because then what happens here is someone exploits a purported opening in the rules, gets a sneak preview without notice or counsel of what questions to ask and all of those things. And then at the end of it all, gets to keep the ill-gotten gains. That can't be the right outcome either. And I recognize there's probably not a perfect solution here, but plaintiffs are the ones that foisted the situation on us in this litigation.
Have you identified ill-gotten gains? I mean, have you identified something that would have been protected? You brought up privilege, for example, or you know, some other type of issue that would have not come out if counsel had been.
And Your Honor, it's not so much.
That may not be fair because it's really
Yeah.
about the principle, but I'm curious.
It's not so much whether anything would not have come out, but for example, both of the O'Reilly managers who were deposed testified about company policies and things of that nature. They were not prepared on those topics. There was no preparation whatsoever. So there's the way that the testimony comes out, the ability to object, all of those things lead us to the point where we honestly don't know how things would have been different. And that gets us to, there's a reason why we have these rules, and there's a reason why we uphold the integrity of the process. So we don't have to sit here after the fact and wonder how it would have looked when we're stuck with the situation that we
Could an investigator have gone to these people and asked them questions and recorded, and then asked them if they would swear to it under oath, what they said?
I think if an investigator went to them and asked them voluntarily to speak, that would be one thing. A subpoena is not voluntary.
What's the difference?
Difference is a subpoena has the authority of the court behind it.
I understand.
Yeah.
I understand it has the authority of the court, but substantively, what's the difference in the information conveyed? I mean, one is, yeah, I'll talk to you. And the other one is, I'm talking to you. And is it going to, the fact that there's a subpoena, does that change the evidence?
Your Honor, I think it makes all the difference in the world. I mean, these are not legally sophisticated individuals.
I'm talking about giving information under subpoena versus giving subpoena voluntarily,
Right.
not with no subpoena, is the information any different?
Your Honor, and I understand there's a natural inclination to want to go there, but that calls into question the entire process anyway. It calls into question all of the.
Well, that's part
we have in the
of,
rules
that's
of
part of doing
procedure.
your Rule 11 due diligence.
Right, but Your Honor, here's the difference, and that is that the subpoena says you are commanded to appear, and if you don't, you face contempt of court. This is coming to legally unsophisticated store managers who, and this is a couple of years after the accident, may feel like they're in trouble. They don't know. They actually don't know anything until they sit down and start talking to plaintiff's counsel. And so there's all sorts of dynamics that can be at play in that exchange. And we tried to highlight a little of that in the briefing.
And Mr. Adler, I mean, for a sanction, I mean, it could come in and say, look, they weren't prepared. We can't use their depositions. Let's redepose them. They're going to be prepared. They have counsel. Those are the ones we're going to use in trial. This was impermissibly obtained. Judge Matthews says, I'm going to fine plaintiff $10,000. How is that not an adequate remedy? That information's out. It's not part of the case.
Your Honor, because it's tainted by the process. And so there's a preview, an improper preview into the information that plaintiff's counsel will not forget when it comes time to, quote unquote, redo the discovery.
So let me ask you, because Justice Bacon asked it earlier, I think. So here it seemed like the court was uncertain whether the rule had been violated and did an order for interlocutory appeal. I just don't understand why we would be the ones to impose a sanction if we found in favor, if we found that the rule was, that the case was final and there's no more discovery, or there was no discovery. So I just don't know why we would be the ones to impose the sanctions as opposed to just remand it, let the court that has the most information, that has the discretion, do it like we always do.
Your Honor, I think the answer to that is that because the district court awarded no sanction, it's an atypical kind of review that you have, because you're not reviewing whether the sanction was good enough. There was no sanction. We have a complete record now with undisputed facts as to what happened in this suit discovery. So the court is in just as good a position to make that decision. But if the court decides it should not give that sort of direct guidance, at a minimum, the court should instruct the district court on remand that the sanction has to be meaningful. And that gets to Chief Judge Chavez's point about, why can't we just do this over or have a fine? But that's not a meaningful sanction because it tells the rest of the bar and it tells plaintiff's counsel, you can go ahead and break the rules and you can go ahead and get a sneak preview without notice or counsel. And what's going to happen is you'll get to still take advantage of that information down the road when it comes time to start over. And that's the concern that we're trying to address with the sanctions. And on that note, just in case there's any doubt about that, there was an argument from plaintiff's counsel that the district court had no authority to sanction conduct that originated in the appointment proceeding. And I think this court's cases make clear that once misconduct affects the case before the sanctioning court, the court absolutely has inherent authority to deal with that. Again, Your Honors, there's not a perfect cure here, but the plaintiffs did create this situation. The integrity of the process is undermined without a meaningful remedy. We think dismissal, while harsh, is appropriate in the sense that it would absolutely cure the prejudice, but we recognize that it's an extremely harsh remedy. But at a minimum, there should be suppression of the improperly obtained information. Because again, once it, as the Kentucky court said, once it's furnished, it cannot be recalled. And so suppression is the appropriate remedy there.
What do you mean by suppression?
Specifically, Your Honor, we mean the information that was improperly obtained. So again, if it's just, let's redo the depositions, that won't achieve anything.
So these, when you say suppression, you're actually saying exclude the witnesses. It's not suppression, it's exclusion of these two witnesses, because otherwise, to follow your argument, if they testify, they're gonna say whatever they're gonna say. Which would likely could have, to use the fruit of the poisonous tree, and that the fact that these facts are in the head of counsel would allow for examination that would be different. So it's really the exclusion of witnesses.
It is, but it also goes to the content, because, for example, here, plaintiffs served discovery and requests for admissions based primarily on this improperly obtained information. So they can't do that, or else O'Reilly still suffers the prejudice. So we're talking about the content of the information. I see, Your Honors, my time is expiring. So I just want to be sure to conclude that we're asking the court to reverse and either with instructions to dismiss or suppress, or at a minimum to remand with instructions for me.
Mr. Adler, I believe Justice Zamora
I
has.
just had a quick question. Was the information obtained used to file the complaint in the wrongful death action? In other words, would they have had the information but for the examinations under oath?
They did conduct one examination under oath of the driver, who was Mr. Ortiz Munoz, and that was with notice to him and his lawyer, and he voluntarily participated in that and gave a lot of testimony about, for example, the fact that he was employed by O'Reilly. So if I recall your question correctly, Your Honor, there was enough of a basis, and O'Reilly denies that there's any liability here, but there's enough of a basis to say this person was employed by O'Reilly. You know, they admitted in the district court that they could have sued Mr. Ortiz Munoz and conducted discovery. The fact that they didn't doesn't excuse what they did.
Anybody else have any questions?
I do. So you argued that plaintiffs have a sneak preview in terms of the information, but at the same time, so does defense. And so if you did a redo or a do-over, defense would have the benefit of knowing how to prepare for objections, and then you could later make the arguments in terms of whether the evidence is admissible. And so what's the prejudice if you followed that suit?
Your Honor, I still think the prejudice leans in favor of plaintiffs in that scenario, because again, they've discovered things without the proper preparation, and we don't know how things would have unfolded differently had they followed the appropriate rules. Thank you, Your Honors.
May it please the court. Ray Vargas, Jeffrey Romano, Nico Harada, and Christopher Winters on behalf of the respondents. If you're going to execute the prisoner, you must first identify the capital crime and convict him. Neither have happened in this case. It hasn't identified a clear rule that has been clearly violated and has not proven the violation of said alleged rule. He's done so willfully, in bad faith, or some other wrongful intent.
So let's have a conversation about that, because I think this was pretty stinky. I'm being super honest. I think this was pretty stinky. District court judges, when they're presented with the request to appoint the PR, do not think that that is going to result in their order, their name being used for any kind of discovery. It's a one and done deal. And so I would have been, as a trial court judge, pretty shocked that this happened. If it did, it didn't come to my attention, but I would have been shocked, because that's not the purpose of that standalone kind of singular proceeding. So to me, it feels pretty stinky. But to your second argument, which is, was this willful? Was it gross misconduct? I want to hear more about why that's not the case, because this feels, like I said, it feels stinky.
Understood, and hopefully I can just of that feeling, Your Honor,
Mhm.
because one thing you may not know is that this is actually a pretty common practice, has been for over 100 years. Mr. Romero will.
And then I'll explore that with you.
Okay,
too.
sure.
But yeah,
Yeah. Lots of plaintiffs' lawyers do that. And Mr. Romero, if you put him on the stand, will tell you that he's done it since 1995. And he's done it, he'll tell you, for the purpose of making sure he's suing the right people. And anecdotally, to use the example that they brought to you in their briefing, case where Judge Wilson told him, no, I'm not going to let you do that. Quash the subpoena. Mr. Romero will tell you, because he quashed the subpoena, couldn't do that limited discovery. He was forced to sue the party that he didn't know might or might not be liable, did the discovery after he sued them, and then dismissed them because he learned, as he hoped to learn before having to sue them, that there was no liability. It's a tool that tells us, are we doing the right thing?
But
Are we
isn't there
suing
an
the-
avenue, there's an avenue for doing that through the rules of procedure, and going back to Ray Chavez, lots of prosecutors had obtained evidence in that manner,
Sure.
and it didn't ultimately mean that it was okay to obtain it in that manner.
And to be fair, Your Honor, there is a process, and it's Rule 27, but we couldn't honestly certify that we could not file a lawsuit, which is one of the preconditions of Rule 27.
I follow.
You have to come to the court and say, I need to take this preservation deposition, because at this point in time, I can't file a lawsuit. That wouldn't have been a true statement, because we could have sued Mr. Ortiz Munoz. We could have just sued the driver. And no one is arguing that had we done that, and had we noticed these depositions and issued these subpoenas in the exact same way, Mr. Romero, that there's anything.
I don't disagree with you, but then file the lawsuit against the driver and do your discovery, because what's happening here, and this is what bothers me, this is why it feels stinky to me, and I don't think, it doesn't matter that it's happened for 30 years.
Sure, I
I
understand.
kind of don't care. For me, it's that if it's due process, it's notice, because having unfettered access to information is fundamentally unfair to the defendant that's not at the table. What if you're asking privileged question, and I'm not asserting that Mr. Romero would ask for privileged information, but what if there is a request of an uneducated, unrepresented person about privileged communications? If that were to happen in opposing counsels at the table, they're going to pump the brakes. And if you continue to have a fight, they're going to go to a judge who is going to understand the scope of the dispute and make a decision. And that's not available here because they're not at the table.
It wouldn't necessarily be available if we just sued Ortiz Munoz, because in most cases, you sue who you think is the tortfeasor, take their deposition, you learn there might be other tortfeasor,
And then you amend.
you notice up the deposition of that witness, and you can take it without giving notice to anyone but them. And there's nothing wrong with that. It happens in cases every day. Plaintiffs do it, defendants do it. Could have sued Ortiz Munoz, taken his testimony, and then said, hey, I think we have other fact witnesses. Let's go depose those two guys from O'Reilly's. Send them a subpoena, just as happened here. And the law does not require any additional notice to anyone.
Except the pending defendant.
The pending defendant will know, but they can't represent the interests.
Well, but they can, so rule, you cite Rule 27,
Yes,
and that, to my understanding, is the only rule, the rules of civil procedure that lets you take a deposition or undertake discovery when there's no pending action. So how do you respond to the argument that counsel makes that Rule 26B requires a pending action, and this is not a pending action?
I disagree that this is not a pending action.
Okay, why?
I disagree that the signing of the order concludes the matter. In fact, if you look at how district courts administer these things, just look at the record they cited to you. I think it's page 8 of their brief in chief, footnote 3. They say a year after this thing was pending, the district court issued a notice of inactivity. District court considered it to be an open case a year later and was using Rule 41 to say, hey, nothing's happened over the last year. If you don't do something in the next 30 days, we're going to
Well,
dismiss.
Mr. Vargas, so the appointment of the personal representative, it's just nominal representative to consolidate actions so that there's not multiple actions filed by different beneficiaries, the ultimate purpose of it. And Rule 26B goes further in that is it's discovery relevant to the subject matter involved in the pending action. So even if we say it's a continued pending action, that action is just to the appointment of the personal representative. So
Or prosecution of a wrongful death claim. And in fact, in this case, the district court put in there to investigate that claim. And that's actually pretty important. That's a good point, because in the Chavez case, which I know you know real well, the court had a discussion about that because the respondent, I don't know whether it was you or your supervisor, argued that there were 3 laws that you need to look at. One of them was a state statute that says attorneys have the power to do certain things on behalf of their clients. One of them was a federal law, and the third one was Civil Rule 45, the subpoena rule, which is what's being used in this case. And when the court was analyzing that argument and rejecting it, they said, okay, with respect to the statute cited, which was 36-11A, we read the language, an action about to be or already commenced, to include only those actions sanctioned by a grand jury or a district court. In this case, it was sanctioned by a district court when the judge entered that order saying you are authorized to investigate and file a wrongful death action.
Let me ask you a different question. Our case law says that the power conferred upon the personal representative cannot be greater than what the decedent would have had. And and citing, that comes from Peck, as I recall. Lopez is distinguishable though, and versus Peck. Yeah, I'm giving you a shot,
Let me
but I'm
shoot my
like,
shot, okay? Because that rule is true if we are purely a survivor wrongful death statute. But if we are a separate standalone wrongful death statute, then we have additional rights. What Lopez said was, we do both. We are a hybrid. Don't just limit wrongful death actions under the New Mexico Wrongful Death Act to those rights which the decedent would have, because we go a step further and we confer specific rights upon the beneficiary. As a consequence, we're not just a survivorship statute. So, and Lopez discussed the fact that we had conflicting statements over the years. Sometimes we say we're just a survivorship. Sometimes we say we're a wrongful death statute. The conclusion of Lopez is we are a hybrid, and you are not limited just to the rights that the decedent. So that's my shot, Your Honor.
I'm not sure that's what the court intended.
That's what it said.
I understand. I'm not sure that this is the result that the court
Sure.
intended in that instance. When we're talking,
This question wasn't there.
yeah, when we're talking about truly, the scope of discovery, why would a PR have greater rights in that instance and the target of investigation have no rights at all? I mean, it sticks with me. I'll
Yeah.
think about it, but it sticks with me.
Yeah, and I guess my answer to that would be, Mr. Romero believed he was authorized by the court order to go beyond just that. And the matter was not concluded because it was still on the docket. It happens all the time.
What about my question? It's a final order.
Is it? I mean, that's the thing.
I think under at least what I've dug into, this is a final
If
order.
it was, then courts would close the file.
Oh, no. Oh, you're
Is that-
putting way, that's hilarious. I mean, there are judges who sit with cases on their docket for 10 years having failed to close them because the attorneys didn't bother to do anything. You have to be a very active judge looking at dismissals for lack of prosecution, and they do that to clean up their docket. It's not the judge's responsibility by any stretch to close the file. It's counsel's responsibility who sought the appointment.
Why don't the district courts treat it as a final order?
I think it is a final order.
You don't close the file. I mean, typically when a judgment is.
I get,
automatically-
no. I did it for 10 years.
I know you know.
In the
Yeah,
eighth, we
so
close them,
it's-
so
Okay.
we
But
close
in-
them
in
right
the
on the date.
In the
Second, they
second, they don't. In the 10th,
I've
forget it.
gotten a ton of lack of prosecution orders.
It's just because you've got
Mr.
a bailiff that doesn't have enough to do and you keep them busy by making them search through your 2,000 files looking to see what's going to be closed. It's not up to us.
Mr. Vargas, a thing that we heard from Mr. Adler, he said, we're here to evaluate first whether this is a pending action and then ask for sanctions. And I'm going to Judge Matthews' order. Judge Matthews' order says, nope, I mean, I'm hearing what you're saying. Sure, I'm not clear whether this is a pending action and you can get at this matter, but the sanctions that you're requesting aren't appropriate. So what is the scope that you see that actually Judge Matthews certified for us to consider?
First of all, I disagree that he did nothing. Because if you look at the transcript, he said, I'm going to give you interlock. He said, I'm not going to let you make them answer requests for admission until there's a clear ruling from the appellate. So he throws
He's waiting.
yeah. And then he said, I'm probably not going to let you use these at trial, except maybe only for impeachment. That's clear in the record. He made it abundantly clear that he did something. That being said, as to your question, I think it dovetails with what Justice Bacon was asking, and that is, at the end of the day, if there is a clear violation, which you don't even have an agreement that there was a rule by the parties or the bench, it's up to the trial court to assess, because they're the ones in the best position, and they're the ones who use of discretion for. So if we were to do anything, the appropriate thing would be to remand to Judge Matthews with whatever instruction you may have with respect to what the rule is. And in light of the fact, if the court determines that it's a new rule. And I say that because you look at the record 2 times before we got here, O'Reilly agreed that it was in the district court. What they said to Judge Matthews, and he asked them, he was talking about the fact that he needed guidance from the Court of Appeals. You'll find this at page 38 at the end to page 39. The court, what about, maybe we haven't explored all the possibilities. What about if I would deny you the relief you've asked for, but grant you an interlocutory right to appeal that decision? In response, O'Reilly's counsel said this. I think that would be a fair point. I think we do need some clarification on this from the Court of Appeals. As Mr. Vargas agrees, I think we don't have a clear indication of whether this is appropriate or not. They admitted in the trial court that there's no clear rule. We don't know.
Are you gonna ping pong back up here? This is, probably up here for at least 3 of us,
Okay.
maybe all 5 of us. Say we disagree with your interpretation of the rule, but we say, not so bad. Goes back down to the judge and pours you out. You gonna be back here on an abuse of discretion question?
Probably will.
I knew the answer, so, but still.
I'm not gonna lie, Justice.
Yeah.
You know that.
Yeah, I just.
So can I go back to the issue of whether this is a pending action or whether it's a final order? Because I'm looking at the petition, the relief they requested was appointing the personal representative, investigating and bringing claims on behalf of the wrongful death estate with full powers of appointment to obtain medical and other records pertinent to the investigation. The orders then filed granting all of the relief that they requested. What other relief or remedy could have been had? Everything that asked of in the petition was granted in the order. So I just don't know what else would have been pending. What other issues, what other relief could have been granted?
Well, it's obtaining other records and investigating. Kind of what happened here is what was contemplated. And that's why we believe.
But do you need the power of the district court to investigate?
You need the power of the district court if you want to do things like issue subpoenas.
Right. And so why couldn't you just proceed in a manner of investigating without issuing mandatory subpoenas?
We, in fact, my understanding is that in fact happened, but because of the limitations of just regular old investigating, things happen like you never learn about those other parties that might be responsible in the suit, might be proper defendants to be brought before the court. That's just one of the issues there. And I want to talk just for a second.
Can I ask you an important distinction that I don't think is equivocally clear, although I looked at Henkel v. Hood, 1945, NMSC 006. But the different roles of the personal representative in a wrongful death action and an overall personal representative. And an overall in the probate, they can deed property. Even after the probate's settled, they have the authority to do things as the personal representative. What's the limitation for a personal representative in a wrongful death action? What are their authorities?
And I'll be honest with you, I've always felt like our decisions are inconsistent in that regard. Because many of them say they're just a nominal party, they're just a straw man, they're just here to be the name on the lawsuit. Then we have cases that say they have fiduciary duty to ensure that the beneficiaries receive proceeds of their, they have more responsibility. And that actually dovetails into what I want to discuss. And that is these proceedings, these appointment proceedings are often a lot more than just appointment. And I'll give you a classic example. PR gets appointed, case settles. No complaint is filed. There's minor children. Parties regularly use the appointment proceeding to go before the court and say, please approve the minor settlement. And the court does that routinely. But under the rule that they want you to adopt, you would have to file a separate wrongful death lawsuit just to get approval of the minor settlement, or a separate petition opening a new case. Because according to them, the second that order was signed, the case is dead and over. But that's not what happens every day in courts in New Mexico. These appointment proceedings are not as limited as they want you to believe they are or should be. It would be a waste of judicial resources if we forced parties to file additional actions. And there are things within the appointment proceedings that can and every day do happen.
Well, in a case like this where you have you know who the driver was in the accident. Why, talking about efficiencies, why not require that the lawsuit and the petition for the appointment occur in the same case, in which case now Mr. Adler is satisfied to give notice and the subpoenas are issued with notice to all pending parties.
Well, if we sued only the driver, Mr. Rattler wouldn't be involved in any way and wouldn't get notice because he represents O'Reilly, which we learned about later. And again, that could have happened in the action had we just the driver. So
I'm going to go back to your approval of a minor settlement scenario.
okay,
So I did a lot of those.
I figured you
yep.
had once or twice.
But there, all of the parties to the suit are given notice. And so there's a fundamental fairness to it. And often it's the defendant that files for the approval of the minor settlement because it's really to protect them. So in that instance, if you had done, an investigation, learned of O'Reilly, said, we're going to sue you, O'Reilly, and O'Reilly said, we're going to give you belly, here's the money. And there were minor children. Yes, you might have the ability to go back in, maybe reopen the petition, because in my court, it probably would have been closed already. So I would get a petition to reopen for purposes of approval of a minor settlement. But everybody involved in the dispute would be invited to the table. So you have that fairness issue covered that's missing in this particular set of facts.
No, and I understand that the court is concerned with the fairness aspect. I get that.
That's really all
I only raise that as an example because if we're going to say that the signing of the appointment means the case is dead and it's final and can't do anything else in it, that's not, as you know, being a district court judge, that's not always the case. They are more than that at times. I want to continue though on the fact that not only did they admit in the trial court that this was an unsettled question, they invoked appellate jurisdiction with the interlocutory appeal statute, which necessarily requires you to petition the court because there's a substantial question of law upon which reasonable minds substantively may differ. And that in and of itself is an implicit express admission that.
So assume with me, I agree with all of
Okay.
that. Or is there any sanction to be levied at all from your perspective? And this might be a better argument in front of Judge Matthew, but.
Absolutely. No, I think from my perspective, if the court were to write on that, would be adopting a new rule, going forward a violation of that rule. Absolutely a sanction might be warranted depending on the circumstances of the case. But in this case, There's no clear rule. Everybody agrees to that. There's no evidence that Mr. Romero was acting willfully. There's no evidence that he was acting in bad faith. There's no evidence of any wrongful conduct. Merely an attempt to do a reasonable pre-filing investigation. And as I said, sometimes you take a deposition, someone says something and light bulb goes on and you think, are there other people I need to talk to? That's what happened in this case. That's it. It happens on both sides. It happens with defendants all the time. Someone not in the case, they take a deposition and they think maybe we should party somebody in. Let's go take a couple of witness depositions and figure that out. That's all this was. That's all that happened. But I will reiterate that I think the appropriate thing, if that's where the court is leaning, is to remand to the district court with the rule, but the district court handled.
So what should have O'Reilly done in this scenario? Because I have thought about, and saying this out loud for Mr. Atler, I've thought about like, where was O'Reilly in all of this? Not communicate. I mean, they know somebody has died on the job. And, you know, where was O'Reilly in talking to employees about if you get contacted, you know, you need to tell us type of thing, or having a policy along those lines. But assume with me that at least for the employee, not the ex-employee, because that's, I think, a little more complicated. But for the employee, O'Reilly finds out what's going on and they're like, oh my God, we've got to do something. What's their recourse for, oh my God, we've got to do something to protect ourselves or prep the witness or anything like that? Or to object to the scope of what is being asked. When there's no pending lawsuit to define the scope, what's O'Reilly supposed to do if that's the scenario?
Well, typically what they would, well, as I said to Judge Matthew, I'll say to you, I sort of felt like what they did here was lodged a collateral attack on another judge's order. What they really needed to do was go before Judge Sanchez Gagne, who issued that detailed order, and say, I don't think this is what you meant, and they violated your order.
So they're going to move to intervene, because that's what they.
Or move for the quash. That's what's been happening in the case that they cite, the Judge Matthew case.
Yeah,
They just
it's motion to quash, like a third party motion to quash.
But that frankly would have been the appropriate place to gauge.
Of course, that assumes O'Reilly would know what was going on and have the opportunity. I agree. I'm owning that was part of my own hypothetical. Okay.
Yeah, and you know, it shouldn't be lost on everybody that the most unsophisticated person here was the driver. And he appeared with very competent counsel for the military effort. And the fact that the managers didn't tell their bosses, hey, I got a subpoena, is not the plaintiff's fault. It's just not. In the scenario where we all agree had they sued Ortiz Munoz, issued a subpoena to a fact witness, if the witness shows up without counsel, without telling their bosses, it's not the plaintiff's fault that they didn't do that. And I hear your honors with respect to the sanction. And I want you to really question and analyze the claim of prejudice. Because it really rings hollow when you recognize that could have sued Ortiz Munoz exactly what we did. Wouldn't have changed a thing. Wouldn't have violated any rules. These two guys still would have showed up without counsel because apparently Bradley has no policies and procedures telling them you have to tell us when you get subpoenaed. And if their argument is, we would have prepped them so they wouldn't have answered questions, well, that's not a good answer. Their answer is, we would have hid evidence, but you didn't give us the opportunity to do that. That's not a good answer either. There's really no prejudice at all. And in fact, Judge Matthew asked that. Can't they just take depositions of these guys and get the same information? As a practical matter, there is no prejudice other than these grandiose claims of, well, you know, the process is tainted. To get there, you have to show that somebody abused the process and violated a clear rule. There's no such violation here. There's no claim. And honestly, you know, there's been a lot of suggestion about violations of the rules of professional conduct. We all know that if a lawyer knows of a violation of the rules of professional conduct, they have a duty to report that. And if they don't, they themselves violate the rules of professional conduct. Nobody has filed a deport complaint in this case. No one has gone to the disciplinary board and said, you know, that Jeffrey Romero guy, he violated these rules of professional conduct. And if they firmly, honestly believe that, they have a legal and professional obligation to do so. But this has gone on for years. There are multiple very good competent counsel, and not a single one of them has taken that step. Proceedings to appoint a wrongful death representative under the Wrongful Death Act do not terminate the signing of the order. Not just that proceeding. No rule was violated by Mr. Romero's use of subpoenas to investigate other potential wrongful death act claims. O'Reilly admitted to 2 courts that it was an open question and there was no clear rule. Therefore, nothing improper occurred. Sanctions aren't necessary or warranted. If this court feels the need to adopt a new rule, remand to the district court, proceedings consistent with that be the appropriate remedy. We respectfully request that you quash the writ. But if not, if you're not inclined to quash the writ, respectfully request that you write an opinion affirming the propriety of what occurred, or adopting a new rule giving clear guidance, since as we saw from the record below, everybody seemed to think there was no clear guidance, and denying any request for sanctions, or leaving it to the sanctity of the discretion of the trial court to determine if sanctions are warranted. Thank you, Your Honor.
Isn't Rule 26 a clear rule? So how are you saying that it would be a new rule when we're looking at Rule 26 regarding a pending action? And it looks like counsel is disagreeing whether it was a pending action, and that's the real issue. So are we looking at a new rule, or are we looking at interpreting a pending action?
Looking at a new rule, because Rule 26 does not tell you that this is or is not a pending action upon the signing of the order by the district court judge appointing the PR. That's unsettled, and everybody's admitted it. Thank you, Your Honor.
Thank you.
Mr. Adler, I'm going to ask you a question right out of the gate because it's the one that's on my mind. You're probably we're planning on answering it in any event. Mr. Vargas makes the point that if they had sued the driver and in the course of doing discovery with the driver, interrogatories, depositions, whatever, they had learned of these additional fact witnesses, they would have been well within their right to subpoena these 2 employees, much in the manner that happened here.
I disagree with the last part. It's not much in the manner that happened here. And the reason, Your Honor, is, and I apologize for not knowing Rule 45 verbatim. However, I think Rule 45 has language that talks about giving notice to those who may have an interest in the subpoena and might want to interpose an objection. When we're talking about a subpoena,
Doesn't Rule 45, no matter which action they do, it was still the same rule under that subpoena. So if the cause was in the appointment, they had to give notice to O'Reilly.
they did. That's just an aggravating factor in this case. But to go to the hypothetical, thanks, Your Honor. To go to the hypothetical, there needs to be, I mean, the purpose of the rule, and it's possible, right, to subpoena fact witnesses when you have absolutely no idea who else might be interested in their testimony, who might want to interpose an objection. But when you're subpoenaing 2 managers of the O'Reilly store after you've already deposed another O'Reilly employee, and you're building your case against O'Reilly around some of that testimony, of course you have to give notice to O'Reilly.
But if I think to Judge Chavez's point, it doesn't matter what proceeding you're in. If that is the import of Rule 45, why aren't you making that argument to Judge Matthew that we were entitled to notice as an interested party, essentially?
We might have not have gotten that specific, Your Honor, but we absolutely.
You haven't argued it in front of us.
Well, we argued that.
Because that's a very, very different argument than what has been presented, and Mr. Vargas has not had an opportunity to respond to that.
Well, he made a clear argument here, Your Honor, that notice to O'Reilly would not be required under a subpoena in an actual.
But if this
pending
is
action.
your argument, lead with that punch, if you think that that's the
I'm
punch.
responding to that argument and admitting that I don't have the language.
Okay, I was just like that, because that's a very different argument.
But it's important to point out too, that Rule 27 is a great example of where this comes into play. Because as Justice Vigil pointed out, Rule 27 is the only rule that authorizes pre-suit discovery. And of course, it has extremely stringent standards, including that you have to give notice to the intended target of the discovery, and you have to apply to the district court for permission, right? And say that you are going to give notice to that intended target. But the purpose of Rule 27 is not for investigation. It's to preserve testimony. We all agree it was inapplicable here. But the upshot for plaintiffs is, well, that rule's inapplicable, so I'm going to go ahead and get my own discovery in this kind of shadow docket over here. Whereas our takeaway from Rule 27 not applying is you get no discovery until you're in a pending action. And that's what makes sense. That's how we use the rules in harmony together. If we conclude otherwise, then I have to ask the court what the point of Rule 27 is. But Plaintiffs' counsel says there was no clear rule. We vociferously disagree because In re Chavez said unequivocally it's unlawful for an officer of the court to issue any subpoena in the absence of a pending judicial action.
Did you concede below that this is an unsettled question? I
We,
believe that was the word.
we did not, Your Honor, on the question of the propriety of the conduct. I think the language that plaintiff's counsel was citing was in the context of a discussion about remedy. And I'll be the first to admit we have flip-flopped all over the place with this. We've been grappling with it because it's a hard question. There is no perfect remedy because what happened here so distorted the rules and the integrity of the process that we're left here trying to identify how to clean it up. And that's why we're asking for the remedies we're asking for. But no, there was not a concession that this was a pending action. You sort of have to wonder, what other pending actions might be out there? It's a petition for a name change. Once granted, does that authorize someone to go pursue discovery afterwards because, it hasn't been administratively closed? That just defies logic. And we have to go back to the statute and the purpose of the appointment, which the court did recently hold in the Lopez case. It is a purely ministerial act. That case was about whether a wrongful death claim that was pursued before obtaining the appointment was subject to dismissal. And the court said, no, you can go back and get appointed. We're not going to be that formalistic. But the purpose of the statute is just to get a nominal party. And that's what that case stands for. It does not stand for the idea that the personal representative has greater rights than the decedent. There's absolutely no support in New Mexico law for that claim. On the question of what O'Reilly should have done in this case, it's important to remember exactly how long it took between the appointment and when the wrongful death case was actually filed. And O'Reilly had no notice before that. That was 19 months of just a case pending. And there were notices of inactivity issued, pro forma notices, as your honors know how and why those are issued. So O'Reilly had no notice. It couldn't seek to intervene in a case of which it had no notice. It is not a collateral attack on the order of the appointment proceeding when we have no quarrel with the order. The quarrel we have is with issuing compulsory court process without a pending action, without notice to O'Reilly, and thereby tainting the remainder of the proceedings. I see that I'm substantially over my time, Your Honors. Do you have any remaining questions? Thank you.
Okay, well, thank you for the briefs. Thank you for the arguments this afternoon. They're very, very enlightening and very much appreciated. The case is submitted and we'll issue an opinion as soon as we're able to. In the meantime, we're in recess. Thank you.